The Honorable Supreme Court of India has expanded the definition of a terrorist act under the Unlawful Activities Prevention Act of 1967.
All right, let's take you to our top story right now. 5 years, no trial yet, no charges framed, and today the top court of the country denied bail to Sharjeel Imam and Umar Khalid, leading to widespread debate.
5 years in jail, no conviction, no trial, no bail. Pre-trial detention continues. Does the dictum bail being the rule, jail the exception not apply? Sharjeel Imam and Umar Khalid in a UAPA case linked to an alleged larger conspiracy behind the 2020 Northeast Delhi riots.
Now, this happened when the Supreme Court of India granted bail to 5 of the 7 accused in the 2020 North Delhi riots. But the court denied bails to 2 individuals, that is Umar Khalid and Sharjeel Imam. And in this particular instance, Honorable Supreme Court of India cited a hierarchy of culpability while not granting bails to the two and granting bails to the other 5 individuals. The court made a very interesting point. The court held the accused do not stand on equal footing, creating a hierarchy of culpability by distinguishing alleged principal planners with those who are having subsidiary rules or facilitative rules, but even though they are facing similar charges under the same particular law. Now, all the 7 accused, they were booked under Unlawful Activities Prevention Act of 1967, also Arms Act and other punitive laws as well. Now, central to this ruling are 2 prominent issues. The first issue is that what constitutes a terrorist act, and second is that who determines it and whether prolonged pre-trial incarceration is justified under anti-terror law or not. Now, beyond immediate bail provisions, this particular court order also expands and broadens the horizons of the Terrorist Act under the UAPA, which will have implications for the future UAPA cases in the country as well, which is why it becomes very, very important. Now, what is UAPA? What is this recent Supreme Court order? And why bail has not been granted to the 2 individuals based on the hierarchy of their rules or hierarchy of culpability? All these questions we'll be trying to answer in this particular session. Hello, my name is Preetpal Singh and you're watching Perspective. Now, first of all, let's discuss about this hierarchy of culpability. Now, the Supreme Court granted bail to the 5 of the 7 accused and did not grant bail to the 2, that is Umar Khalid and Sharjeel Imam. Now, the reason given by the Supreme Court was that this decision of Supreme Court of granting the bail was based on individualized assessment of culpability of individuals, which means and which holded that the accused did not occupy same position within the alleged conspiracy. The conspiracy of conducting Delhi riots, the alleged people, the people who are alleged to have orchestrated the riots, they are not in the same position. And why they are not in the same position? Because the court noted that there is a clear hierarchy of rules which can be seen. And rather than treating all the accused equally, they are not to be treated equally because there is hierarchy amongst the accused. Now, what is the hierarchy? The Supreme Court said that the 2 individuals, Sharjeel Imam and Umar Khalid, they are principal accused, which means the court found in these 2 cases that the prosecution material placed them at the level of conceptualization, orchestration, direction, and mobilization of riots, which means they were the masterminds, alleged masterminds of these particular riots. And not just this, both the individuals were described as ideological drivers or masterminds who were allegedly responsible for strategizing the transformation of protests against the CAA Citizenship Amendment Act into a chakka jam, disruptive chakka jam, which is aimed for paralyzing Delhi, which was aimed at paralyzing Delhi at that particular moment in 2020. So these 2 are the accused who are masterminds or alleged masterminds who strategized for the conversion of a protest to a disruptive chakka jam, which was aimed to paralyze Delhi. This is what prosecutors are saying. And these allegations, according to the Supreme Court of India, they suggest a central and directive rule, which is very different from a subsidiary rule or a facilitator's rule. The first rule is that of a mastermind or a central rule. And the second hierarchy which the Supreme Court of India justified was the co-accused who were granted bail. Their hierarchy was that of peripheral rules, which means in contrast, the 5 accused which have been granted bail, they were local level facilitators or they were actually site level executors of the instructions being given by the masterminds, which is why their rule by the court is termed as a derivative rule, indicating that they acted on the instructions which were coming from a higher authority, coming from the planners who orchestrated this particular whole event. And they shaped the entire conspiracy. But these individuals, 5 individuals who got the bail, they were not the masterminds. They were not the orchestrator of the entire conspiracy. And which is why the court held that the continuous incarceration of these minor participants would be disproportionate, especially since the investigation was complete and the trial had seen significant delays. Which is why it was right for the court right now to give all these 5 accused bail, but not giving bail to the other 2 individuals, because these other 2 individuals are the alleged primary facilitators of these particular riots. Now, since we have understood that why bail was not granted to the 2 individuals, first of all, let us look at what is a terrorist act under the UAPA. So, Section 15 of Unlawful Activities Prevention Act, it defines a terrorist act as one which is carried out with an intent to threaten India's unity, integrity, security, economic security, or sovereignty, or to strike terror amongst the people. This is what a terror act constitutes under the UAPA Act. Now, this provision also lists methods such as bombs, explosives, firearms, or inflammable substances, and also adds a broader clause of any other means as well. Now, the prosecution has argued that the alleged chakka jam or the road blockade planned by the accused could fall under the Terror Act, which means could fall under the any other means which was provided under the Terror Act, even if it did not involve use of conventional methods like use of bomb, firearms, or all those things, weapons, but its intended impact and the consequences are the same. This is what prosecutors are saying. So prosecutors are simply saying that now under the Terrorist Act, these chakka jams, road blockades, based on its intention and based on its consequence, could also be included under the Terrorist Act under the pretext of any other means which was written. If you remember, I told you the provisions lists where it was bombs, explosives, firearms, inflammable materials, and there was also written or any other means. So under this or any other means, chakka jam can also come. Road blockade can also come. And this is what prosecution has argued. Now, of course, defense countered it. And according to the defense counsel, they contended that the road blockades, they do not constitute a terror attack, but they are legitimate democratic protests in a democratic country. And since Section 15, it primarily refers to violent methods, he argues that any other means should be read narrowly and should only include other violent means rather than these road blockades. Now, the question is, what is Honorable Supreme Court of India's view? The Honorable Supreme Court of India rejected the claim of defense and accepted the prosecutor's claim and said that these acts were not mere political dissent. And the court accepted the prosecutor's point of view that sustained choking of the roads and systematic disruption of civic life amounted to calibrated acts threatening India's unity and integrity. Which means any road blockade or any blockade of arterial roads or systematic disruption of civic life in a society, in a country like India, can amount to the calibrated act threatening India's unity and integrity, which is why it can come under the Terrorist Act. And also Supreme Court of India said that when such blockade are planned, are synchronized, and are timed with the international events like Donald J. Trump coming to India during the 2020, this prima facie may fall within the definition of Terrorist Act under the Unlawful Activities Prevention Act. Also, the court said that the focus is not on the weapon used, but the focus is on the design, intent, and effect of the act which is carried out and which is to be treated as a terrorist act or not. Now, this is where actually we are saying that because of the Supreme Court's order, the definition of Terrorist Act has actually been expanded. And this could set a precedent for the cases to be decided in future under the Unlawful Activities Prevention Act. Now, there is also a mention of Section 43D subsection 5 under the UAPA Act. Now, this particular section of the UAPA says that bail is barred if accusations appear prima facie true against an accused. Now, applying this, the court found that the witness statement, the chats, and the meeting records establish a prima facie conspiracy against Umar Khalid and Sharjeel Imam. which is why the statutory bar on bail operated fully against them. Now let us briefly know about UAPA Act before concluding the session. Unlawful Activities Prevention Act of 1967, it was enacted to address the anti-national activities and secessionist movements in India which were going on at that period of time. It was also passed after the peasants' uprisings in Naxalbari, which means after the Naxalite movement. And it is also known very famously as India's anti-terror law. It is a very important piece of legislation to maintain internal security in India, and which is why the main goal of UAPA is to prevent any unlawful activities in India which will be threatening India's sovereignty, integrity, and security. Now, in the present form, UAPA includes both associations and individuals to be declared as unlawful and has provisions for punishments for the both, which is why further it has provisions to prevent the use of funds for terrorist purposes, including money laundering provisions as well, making this particular act more stringent. Now, it is having multiple major provisions. For example, it can declare an unlawful association, which means it is having the power of declaration of unlawful association. Also, not just this, it is also having the power for declaration of a terrorist organization as well. And under this act, the central government may designate any association as a terrorist organization if it is committing or perpetrating any act of terrorism, if it prepares for terrorism, if it promotes terrorism, or is otherwise involved in terrorism in any shape or form. Now, this particular act also defines what is a terrorist act. And not just this, the central government may constitute a tribunal under this particular act as well, known as UAPA Tribunal. And one more important thing to note here is that under this act, the bail provisions are very, very stringent. And in order to get a bail, the onus is on the person, the onus is on the accused to prove that the person is innocent, and not on the government to prove that the person is guilty, which is why the bail provisions are very, very strict. And the punishment can also go up to death penalty or life imprisonment under several acts under the UAPA. And last but not the least, but very important information, National Investigation Agency NIA is the central authority and is having the power to investigate the cases under Unlawful Activities Prevention Act. And NIA is a statutory body which was formed in the year 2008 based on NIA Act. And NIA is a statutory body which was formed under the National Investigation Authority Act of 2008. Now, in the year 2019 itself, the Unlawful Activities Prevention Act was amended and it was made more stringent and more robust. And very recently, in the year 2026, the Honorable Supreme Court of India has expanded the definition of terrorist act under the Unlawful Activities Prevention Act of 1967. And this was our topic for today. I hope you gained a perspective from this particular session. Do let me know what are your views surrounding it in the comment section. I'll be very happy to read them. All the very best and have a beautiful day. Thank you.